We're going to talk to Maria right now. Maria, welcome to the Law Show.
Hi, thank you for taking my call. You guys are great.
Thank you very much. I appreciate it. What can we do for you?
Well, 6 months ago, I became my sister's legal guardian. She is legally incapacitated. And when I agreed to become her legal guardian, her conservator, she was given a conservator by the courts. She has like $20,000 in her that he's holding on to.
Okay.
Anyway, he said, if you get your other sister off, because I don't want to deal with her, but if you become your sister's legal guardian, I will help you, and I will sign off after 6 months. If you're doing a great job, I will sign off. And
okay,
so
wait. Hold on. I got to ask you a couple of questions. I'm a little confused. You're the guardian of your sister who's obviously disabled in some way.
Correct.
Okay. You have another sister that is also a guardian?
I had my sister who was guardian before me of my sister who's incapacitated.
I got it. So you're the sole guardian now. You replaced your other sister.
Correct.
All right. And your disabled sister's conservator has money that he refuses to let go to you for expenses in relation to your sister.
Well, he said he'd help me, and then it's been 6 months, and I haven't asked him for anything. But after 6 months, he said he would sign off.
Okay.
So when I called him, I told him Isabel's needs, and then I also mentioned to him that it had been 6 months.
Okay.
And then he went on to tell me that there's this new law that if I want anything for Isabel, I need to write it down and give him quotes and then mail it to him, and then he submits it to the courts, and then they decide whether or not to release it, because that's the new law.
Okay, now wait a minute. There's something that doesn't smell right about that. It sounds like he's sort of injecting himself into the discretionary part. What do you think, Matt?
Well, first let's start with the fundamentals, Brian. We've got two things going on here. We have the guardianship. Guardianship relates to the incapacitated individual's health and treatment, such as whether or not they get an ear operation, what type of medication they take, whether they go to the doctor, and that type of stuff. Then you've got the conservatorship. The conservatorship has to do with the financials, the money of the incapacitated individual, what gets paid for. And you've always got kind of an interesting dynamic when you have one person as the guardian and a different person as the conservator. Because then the guardian may say, hey, she needs this money for this doctor bill, and then the conservator has to agree with that and get the court to sign off on it. Whether or not, in this particular situation, the conservator has the authority to grant the money to the guardian on a request without court intervention, I would have to have more information to make that call. But the conservator is correct that due to recent changes in the law, there's a lot stricter and closer court intervention and control over what money gets dispersed by the conservator. The best thing that this sister can do, who's the guardian right now, is document everything in writing. Because if she needs, a medical bill to be paid for, the guardian should not be paying for it out of her own pocket, even if it's her sister. She's got to document every single thing, get copies of all the bills, all the receipts, and show them to the conservator to ensure prompt repayment.
But, Matt, doesn't that increase her legal costs? Because now she's got to go out and get her own lawyer, and why is this lawyer standing in the way? Can she just file a petition with the court herself and ask the court to provide these funds without having to send them to the conservator who's going to then bill the estate? I mean, that's what's really going on here.
Well, and that's the problem here. When the caller was talking about after 6 months, this court-appointed conservator, who I assume is a lawyer, is going to get off the case, what I assume by that is he or she was going to transfer their conservatorship authority from themselves to the sister who's the guardian right now. I think that's what's going on. If that's what's going on, whether or not this guardian can convince the probate court to appoint her the conservator as well right now, I just don't know that. I don't know why the court, I don't know why this sister who's the guardian didn't say, hey, also make me the conservator. Because when I've handled these types of probate cases, Brian, it's a lot quicker, which is a lawyer way of saying cheaper, if you've got one individual, assuming they're competent and they're acting in the ward's best interest, to serve as both the guardian and conservator. Now, that's not always possible, but it makes it a heck of a lot more efficient.
Does that answer a question for you?
It really does. I would never have taken it on had he not agreed to help me, because my husband got laid off with everybody else a few years back, and now he's back in school, and I just feel like I'm being strung along, and I don't know how to deal with it.
Well, I've got a suggestion for you. I'd like to invite you to take advantage of our free initial consultation, to come in and sit down and talk with Matt. Bring all your paperwork with you. Bring all of your stories with you, and talk to him. He'll give you as much time as you need in his office, and there's no charge. There's no charge until you decide that you want to hire us. And what we would probably propose to do is to petition the court and point out to the court that there's only $20,000 here. And your sister, is she receiving Social Security disability benefits as well?
Yes, she is.
And are you the representative payee of that?
Yes.
Okay. So what I would propose is to have you think about retaining Matt to petition the court to make you also the conservator, so that you can make your own decisions. And then you're in a spot where all you have to do is just report to the court. Isn't that right? Rather than going through somebody else?
Well, yeah, because every time, like you pointed out, Brian, if this court-appointed conservator is an attorney, which they usually are, what they're doing is they're billing the estate for all the work. So that's an extra hoop you have to jump through, and that's that much less money that's available for Isabel, and instead is going to go to this court-appointed conservator.
All right. So listen, why don't you give us a call, Maria, at 855-LAW-SHOW during regular business hours. Ask for Colleen, that's the assistant for Matt Kachik, and schedule an appointment to come in and see Matt. There's no charge. You can take as much time as you want. Have a cup of coffee, sit down. Bring your husband with you. If we need to schedule an extraordinary time outside of business hours, we can do that. We'll make it convenient for you and your husband to get the answers that you need, okay?
All right. Well, thank you very much for your time.
Very good.